Councilman Pennington to lay out his amendment.
Thank you, Mayor. I think that the goal and discussion with you, and I think everybody at the table too, is to end discrimination, and you do that inevitably by deferring, certain rights, reserving certain rights that might, as shown by the opposition to this ordinance, at least the communication I received, abridgment of other people's rights, and I know there's argument about whether that's the right term. But I think that the hope of everybody is for everybody to get along and to respect each other's rights. And my thought is, and the reason why I offered this amendment is, if there is not the threat of criminal sanctions, but only having to go through an investigation and drilling by the Office of the Inspector General and all that's associated with that, that for a first offense, deferred adjudication ought to be offered so that there would be no criminal record of this, even though it's a Class C misdemeanor. It does create a criminal offense, not a civil offense. And that I think in the long run, it would be good, a better way to get the communities together than with the criminal sanctions being threatened. And that is the amendment that I offer for a first-time conviction for an offense.
Councilmember Boykins.
Mayor, I want to let my colleague know I'm a big second chance guy. I love this. I think this is a good amendment. I think if a person realize that they made a mistake, because I think the intent of this whole deal is to make certain that it's a fair process and to everybody. And this speaks to that. I believe that if someone made a mistake and they come back and clean it up within that year, that they should be taken off. So I'm a big second chance guy.
Yeah, Councilmember, if I may, the reason that something like this wasn't already in the ordinance is that municipal court judges already have the discretion to do exactly this. This guarantees a second bite at the apple, as it were, or a mulligan. We believe that it is within the discretion of a municipal court judge to decide on a dismissal or deferred adjudication, and that is the appropriate place for the discretion to be, rather than an amendment that removes all discretion from a municipal court judge. Councilmember Kubach.
So, Mayor, if this is going to city municipal court, there's going to be a citation number. Is that correct?
Mr. Feldman, would you describe the process?
Yes, sir, there would. It's just like any other.
Okay, the citation number is going to be a public record. Is that correct?
Yes.
And so they'll be solicited by lawyers who get records from the municipal court every day.
Well, I don't know if we can go embarrassingly, I suppose it's possible.
Well, you know that we do, because I've had your staff come and talk to me about those issues already and how we're doing that. So they're going to be soliciting, and I was under the impression that the people charged with this offense, they would not be made public until they fail to comply with with the Office of the Inspector General, and it would come to City Council for a subpoena. So this is going to be a public record right from the get-go.
No, that's incorrect. Mayor, now respond, please. We only get to the point of filing a criminal complaint, council member, if, number one, complaint is filed, number two, the Inspector General investigates, number three, the Inspector General concludes that it's meritorious, number four, the place of business or the employer refuses to conciliate, and then number five, I have to make a determination that we can establish proof beyond reasonable doubt that discrimination has taken place. If I conclude that on that fifth step, then I would file a complaint. The citation number would be secured, as you pointed out, and would be treated like any other offense in municipal court. But that is way at the end of the road. The process prior to that is a confidential process unless the individual